Everybody. This is Cy Alba, a partner with Polaro Mazda, and I'm here with my colleague Anna Wright. As everyone knows, we're going to be talking about Section 889 of the 2019 NDAA, the prohibition on use of certain Chinese telecommunications equipment and services. I know this has been kind of a hot topic for a lot of folks. We've been getting a lot of questions on both Part A and Part B, which we'll kind of touch on A. Most of this will be about Part B because Part A went into effect last year and has been in effect for over a year. So I know a lot of people might not have been aware or something because we've been getting interesting questions. But as people might know, I'm Cy. I'm a partner in the government contracts group that can do all things federal contracting. And one of the key areas that I've been personally dealing with here happens to be Section 889. And I'm here with my colleague, Anna Wright.
Hi, I'm Anna Wright. I work a lot with Cy. I especially work frequently on cybersecurity issues, how that intersects with the False Claims Act. I also work on claims, protests, all that kind of stuff. And recently, of course, I've been working with CMMC and this new-ish Section 889 issue.
And generally about us, quickly, Polaro Mazda, we're a full-service law firm for small to mid-sized companies. Do a whole host of issues from labor and employment, litigation, corporate M&A work, and also government contracting is one of our main specialties, as probably most people know. Okay, and as an overview, what we're going to get into is sort of a background of the different rules, Part A, Part B, go into the applicability of the rules, walk through some of the banned entities, products, or services, the key terms, the flow down realities, because there is no flow down to Part B, but that's not the full story, so we kind of want to go through there. There's a lot of confusion about the waivers, so we're going to go through that, and then sort of open issues or implications of the rules and sort of practical impact. So with that, Anna, you want to take it away?
Sure. Yeah. So a little bit of background on Section 889. Section 889 here refers to specifically Section 889 of the 2019 NDAA. Now, as Cy noted, there are two different parts that are at issue. There's Section 889A1A and A1B. A1B is the primary focus of this presentation, and that was implemented in the FAR as of August 13th, 2020, via an interim rule. So that happened last, what was that? Would have been a Thursday, I think. Yeah, a Thursday. So Part A has actually been in effect since last year via the clause at FAR 52204-25. This Part A prohibits executive agencies from procuring or obtaining telecommunications equipment and services from the list of prohibited Chinese companies. This piece of the prohibition only applies if the prohibited equipment or services are the deliverable, or if the equipment is a, quote, substantial or essential component or critical technology of any deliverable. Now, that doesn't mean that the piece itself is considered a critical technology, I'm using scare quotes, but rather that the prohibited product is a part of what's being sold to the government, without which that product wouldn't work. That's what critical technology is in this context.
Yeah, because not just with Part A, but with Part B as well, there's been a lot of confusion around this. And I've heard clients confused that, well, the Huawei product or something or component is not a substantial or essential component of something I use for my business. It's not essential to my business. It's just, the security camera that's outside of our building or something like that. But that's not, again, what Anna said, that's not the rule. The rule is not that it's substantial or essential to you, or that it's critical to you. It's that the component or the item is substantial or essential or critical to whatever the thing is that it's a part of. And that's important to note. Again, though, for Part A, this is the things that you're selling to the government. Whereas, and then here's some of the reporting.
Right. And so for Part A, there are certain reporting requirements. If you discover that you're accidentally selling this prohibited technology or any services using this technology to the government, you have to report that via DibNet within 1 business day. Within 10 business days, you have to take some additional reporting steps to detail the steps you're taking to mitigate the impact of that discovery, how you're going to phase out of your system, and how you're going to, in the future, keep that from happening again. Section 889 in general, both A and B, applies to all executive agencies. There's no limit here for particularly Part A to the types or the size of contracts to which this prohibition applies. So it includes COTS items and micro purchases. And Part A, in particular, has to be flowed down to subcontractors. So subcontractors can't sell to you, who then sells to the government, these prohibited products or services.
Right, or products that have these components that are substantial or essential or critical technology. That piece of it as well, you can't sell that to the government. And so again, A is all about what you're selling to the government, not what you're using yourself. That is Part B. So you want to walk through Part B?
So Part B, like Sai said, is all about what you yourself are using. Again, this applies to all executive agencies, so will apply outside the FAR. We don't know yet how other agencies that aren't FAR covered are going to implement the ban, just because the rule, the interim rule that we're looking at here, only applies to the FAR. At this point, unless a waiver exists, this Part B ban applies to all prime contractors performing any FAR-covered contracts. It only applies to the prime contractors and also to their affiliates, because there's this broad, do you use these prohibited products or services inquiry. But there are some intricacies with respect to what use means that will probably require you to obtain information from your subcontractors or vendors. Like Part A, there's no exception for commercial item contracts, small businesses, etc. And it's also likely that non-executive agencies will implement these same requirements.
Right. And so some of the issues with these foreign affiliates, I've heard that talked about, where I don't know if many people on the line actually have foreign affiliates, but there's been a question about, will this apply to those foreign affiliates, or will it just apply to domestic affiliates? So it seems like right now, when the rule goes final, which might not be for another year, that foreign affiliates might be exempted, but they might put some brackets around that. So as of right now, it only applies to you as the offeror, but we'll get into some of the nuances like Anna mentioned about use in a little bit.
Right. So this new requirement is a material solicitation requirement for all solicitations after August 13th. That includes contract awards made after August 13th, even if the solicitation was on the street prior to that time. That requirement applies unless a waiver is granted to the agency. We'll get into how waivers work a little later in the presentation. Failure to certify that you, the prime contractor or prime offeror, are not using the covered equipment or services is a valid basis for rejecting an offer. And in fact, arguably, agencies are required to reject offers because of the statutory ban. As Sai noted, it doesn't apply to affiliates and parents and subsidiaries at this point yet, but the FAR Council may make it apply. And as Sai also noted again, the final rule is expected to take effect in August 2021, but that doesn't mean that you can't, or that you should apply now, or apply this prohibition now, because it is prohibited per the statute.
Yeah, and I think that's part of the confusing part right now, is that the rule, the interim rule, is an actual rule. It is effective as of August 13th of this year, 2020. And while the final rule might change some things, it's by sometime next year, say August 2021. The fact remains that it is the current law of the land. There's also been some discussion about maybe the next coronavirus bill, pushing it off even further, or suspending the application of the current rule. But we don't know what's actually going to be in there. So as of right now, this is a current rule, and it might change, but what we're going through right now is the best of what we have, the best of what we understand.
Yes. So the reporting requirement, we mentioned earlier about Part A. That same reporting requirement applies for Part B as well. Again, this is ongoing throughout contract performance for every contract. If you identify that you're using covered equipment, you have an obligation to report that use within 1 business day, and then perform a follow-up within 10 business days. And I'm not going to go through that whole wall of text right now, but you can read it yourself and see there's a whole lot of stuff that you have to report. So importantly, this doesn't mean that you can make a one-and-done certification. You have to keep track throughout contract performance of what information or of what products and services you are using. And yes, someone has asked if Part B applies to equipment used by a small business in its business operations. Yes. We'll get to that more later, but yes, it applies to all businesses, regardless of size. And so does this reporting requirement. It applies to everybody.
Yeah, and as you can see in the 10 business days section, that gives you an idea, the other text is underneath, gives you an idea of why they're looking for that. And the fact that they want you to tell them, well, what efforts did you take already before you discovered this sort of breach, if you will? What efforts did you take to make sure that kind of issue or use didn't occur? And then in addition to that, what additional efforts are you taking now to make sure it doesn't happen again? So the clear thrust of this is that you're not supposed to be using it, period. And if you are using it, then that's a violation. And they want to know exactly how that happened and how it's not going to happen again. So this is not the kind of thing where it's, oh, I'm sorry, I discovered this. So for the fact that I use like a Huawei, say, cell phone, one of my employees conducts all their business on a Huawei cell phone, and I forgot to ask them, and now I just found out about it. Can I just keep doing that? No. You need to then figure out how to replace that person's cell phone. Okay, like that's the kind of thing that is required by this. Speaking of Huawei, these are,
yeah,
right?
Yep, this is the list of banned entities. You can read it yourselves. I won't regurgitate that for you. But it also includes their affiliates. These affiliates are, each of these companies has a ton of affiliates. If you Google them, you'll see that all of these affiliates just popping up everywhere. Most of the affiliates that I was able to find have these names somewhere in their name. But there are a few that don't. Like, for example, Hytera is also affiliated with Teltronic and Norsat. Just fun fact. The ban also applies to any company the Secretary of Defense, quote, reasonably believes is owned or controlled by or otherwise connected in some way to the government of the People's Republic of China. We don't know yet how exactly the reasonably believes piece is going to work out. We also haven't really had any visibility into how the Secretary of Defense plans to notify industry of what these specific companies are, but we'll, of course, keep you posted as we find out how that's going to work.
Yeah, and there's also been talk about providing a more fulsome list at some point. But as of right now, there isn't a complete list that I'm aware of every single potential affiliate, and certainly not these reasonably believed to be controlled by the Chinese government lists. And so I would imagine this will continue to develop, And there's nothing that prohibits, say, a contracting officer or DOD or the Director of National Intelligence from discovering another affiliate or another entity and passing that down to the chain, such that the CO amends the solicitation or something like that to add a company. So I think that might be the way this would continue to happen, but we're just not entirely sure as of right now. And it's also not all their products, right, Anna?
For Huawei and ZTE, yeah, no, it's not necessarily all their products. No, there's a specific subset. But, of course, it's the subset that they primarily manufacture, so that's only mildly helpful.
Yeah, and so this is a list of the various products. So the telecom equipment, telecom and video equipment by some of the other entities, and we have some examples here. So, Huawei makes a lot of phones, and we do think that if an employee is using a Huawei phone to conduct their business, and you as a business or, that employee is talking to customers or yourself or internal communications using your cell phone, especially now, where people tend to be working remotely a lot, that would be the use of that equipment by the company. So that needs to be replaced as soon as possible, or you can't make the certification. When it comes to different surveillance equipment and things, something that's come up is thermal cameras. My understanding is Hytera makes a lot of thermal cameras, and some companies have bought a whole host of those in order to review individuals coming in and out of the building and cataloging that. So long as the exception doesn't apply, which we'll get into in a little bit, that those cameras might have to be removed, taken down, and thrown in a trash bin. So that's the kind of thing that this rule is going to require, and it's not just using it here. So if you're using surveillance equipment in a warehouse in China, this is another example. If it's your warehouse and you just have surveillance equipment there to monitor, and that surveillance equipment communicates back to the United States, into your systems and servers, or even if that communications equipment is capable of collecting packets and communicating any information anywhere, that is still a prohibited use, even though it's a warehouse that's in China with your equipment. So it's any use, no matter where it is, if it's your company using it, even if it's entirely unrelated to federal contracting. So again, say you have this warehouse in China and you use it because you have a retail wing of your company that does T-shirt sales, and you're an IT services provider to the government. It doesn't matter. That T-shirt sales division in your company is using, say, these prohibited Hytera cameras. That needs to be purged, or you can't make the representation. So it's very broad. And now we'll go through some of these key terms that are really important. Go ahead, Anna.
Yeah, so the definitions of these terms used in the prohibition are in FAR 4.2101. However, several of these major terms are vaguely defined, or they're just not defined at all. A good example of that is the word use. What does use mean? And we'll get into that a little bit more later too. So the first term is covered telecommunications equipment or services. Equipment means both telecom equipment produced by these corporations and telecom and video surveillance equipment produced by Hytera and the others. Services means telecom or video surveillance systems provided by such entities or using such equipment. This also applies to the products and services, of course, that the Secretary of Defense, quote unquote, reasonably believes is owned, controlled, or otherwise connected to the Chinese government. Again, we don't have a clear list of that yet, but we will keep everyone updated as to if and when we find that list or when it's released. Next term is a reasonable inquiry. Reasonable inquiry is defined as an inquiry designed to uncover any information in the entity's possession about the identity of the producer or provider of their equipment or services. It stops short of an internal or third-party audit. Entity presumably means contractor, but again, entity is not defined. Substantial or essential component, as we noted earlier, means a component necessary for the function of the product or service in question. It doesn't mean something that is essential to your business. It just means it's essential to the function of the thing you want to use.
Yeah, and I've heard certain interpretations about the reasonable inquiry rule. And again, this is the actual definition. And as you can tell, there's a lot of holes in this and a lot of room for interpretation. And so some people have interpreted this in a more conservative manner, basically saying, look, reasonable inquiry can change from company to company. Like if you're a landscaping company, you might not have the same sort of knowledge as to what questions to even ask, as opposed to someone who's a cybersecurity company specializing in Chinese counterintelligence, right? In that case, is it reasonable for you as the cybersecurity Chinese counterintelligence firm to not pay attention to certain things that you know about or should know about, as opposed to the landscaping contractor that has no clue? Another thing that's come up is this idea of the inquiry is designed to uncover any information in the entity's possession. And that, combined with the fact that it says you don't have to have an internal or third-party audit, external and internal audit, does that mean it's only the information that you already have that's sitting there, that you already know about, or that is in the minds of the current personnel that you have? You could read it that way. I do think, though, because of the vagaries here and the seriousness that at least has been communicated about this from the Director of National Intelligence, that this is not a attempt at economic warfare against China, that this is supposedly, you the judge, this is a actual intelligence threat from China that needs to be dealt with, and it's very serious. That's what GSA has said. That's what others have said. And so because of that, I could see DOJ or the IGs taking a more expansive view of this as if there's information you could have gotten by a simple phone call or asking about it, talking to your IT providers, etc. Is that really a reasonable inquiry if you just failed to do that? Or another thing I've heard from folks is, just really quickly, another thing I've heard from folks is just, hey, I know a lot of my providers or the suppliers I use have lots of ties to China. I don't know if I want the answer to that question. Do I really have to ask them? This does give you some wiggle room there, but if you have a hunch that there's something there and that's why you don't want to ask, that could turn into a potential issue, which is a potential FCA issue, which we'll get into at the end as well. Sorry, Anna, go ahead.
Oh, I was just going to add also just a cursor at Google is never a bad idea. Because if there's something on the front page of the New York Times and you somehow magically missed that, that's not going to look great to, say, the OIG.
Right.
Okay, so about that reasonable inquiry, how do you know what's in your possession? That's a really good question. Be broad. Make sure you are diligent. Check with your third-party IT providers, like we've said here. Do a quick Google, all that kind of stuff. Just verify what they're using. The ban doesn't flow down specifically, but you still should do your due diligence. If you fail to inquire, you, the prime contractor, the Department of Justice or inspectors general could consider this reckless disregard for the truth and therefore False Claims Act territory, which is not a fun place to be. There has been some speculation that you don't actually have to check with your third-party providers. This depends on how conservatively you want to interpret audit. We have used a conservative interpretation here of really performing your due diligence and making sure that you're not goofing anything up accidentally. But there has been some speculation on the other end of that as well. It's also a good idea to ask your employees and anybody who connects to your Wi-Fi what networks or networks what products they use, because if your employees are using, for example, a Huawei phone, that's for your business purposes, and they're connecting to your network and they have all this accessibility to all of your information. That's a pretty clear use of this prohibited technology in your system. So that would be something you definitely want to inquire after, so you're not on the hook for that violation.
Yeah, and even there, even if you take the interpretation that it's only the information in your possession that you already have in your possession, I think it's certainly unreasonable to say that the knowledge of your employees is not your knowledge. I think it's probably imputed. And so if it's something where your employees know about something that because they know it, you should know it. There should be some reasonable inquiry, obviously. And especially if you bought the phones, and you should know that fact. So what are some of the options?
Yeah. So get rid of it. That's a good option. But that's not always feasible. So what are other options available? You could try disconnecting the devices until you figure out a way to deal with it. Turn them off, disconnect them from your internet or network. One question that remains kind of vague is whether you have to inquire as to the use of such covered equipment by your vendors and service providers. So, for example, if you get your internet from Verizon, do you have to inquire whether Verizon uses any of this banned equipment in the services they provide you? And it's not clear from the rule presently to what extent your service provider potentially using that equipment to provide a service to you would count as you using that equipment. That was not clarified in the rule.
Yeah, and I think is, in my opinion, is that's kind of tangential. And same thing, we've gotten a number of questions about, well, what about like my Apple phone or my Samsung phone or whatever? How do I know there aren't components inside those devices? Nothing here, I don't think it's reasonable to say you got to go down the rabbit hole and uncover every element of every piece of technology that you have, nor do you have to take them apart or anything like that. I think if it's obvious, like a Huawei phone, for instance, okay, that's an issue. Whereas if it's a Samsung phone, an LG phone, an Apple phone, old like Microsoft phones or whatever, right? Those sorts of things, you can look on its face and take it at face value that, look, I don't know what's exactly in there, but there is no reasonable way for me to inquire into that. I could see an exception if there was some major news story that broke in the federal news radio or something that tracks the government contracting space, where there's a big news story that the iPhone 11 contains critical Huawei communications devices or something like that. I think at that point, if it gets widespread or goes viral, so to speak, then that sort of thing, I don't see how you ignore it. I think at that point, you'd have this obligation to go through and say, well, we're all using this, and report it. Now, frankly, half the government uses iPhones. My wife has one. So I think that kind of thing, you're probably okay on Samsung, LG, Apple, the major providers here. Okay, so what about subcontracting, Anna?
Yeah, so the prohibition at FAR 52204-24, that's the A1B prohibition that we've been talking about, is not a required flow down to subcontractors. So subcontractors, if they're only subcontracting, can continue to use the prohibited items or services generally in the running of their business. But they can't use those prohibited items or services directly in the performance of a covered federal government subcontract, because it has the same issue with use, using scare quotes, as the prime contractor. Like, to what extent is the prime contractor using this covered equipment or service because of the subcontractor using it?
Yeah, and I'm sure there's many other examples, but one of the ones that I've used in the making the example is to say, let's say you have a subcontractor. That subcontractor has this theoretical warehouse in China that we just talked about, and the warehouse in China, they use a Chinese, like let's say Huawei has a security division or something, and they use the services from that division to protect their warehouse with Huawei cameras and Huawei communications equipment that all goes links to the internet and talks to everything, right? But in the contract they're doing for you, the subcontract, they are providing bodies in the U.S. to do IT services, and the IT services are provided on site or something like that. And it's just a human being sitting there, and all their phones are Apple or Samsung or whatever. In that case, the subcontractor is not using that technology for the purposes of providing it under the subcontract to you as the prime. And so all of that prohibited technology that's in the warehouse that we talked about, that's not germane to your prime contract. And so because of that, the best interpretation is you are not using that. However, if you're in a situation where your contract is for security services and you have personnel who are wearing certain cameras or using certain security cameras that are developed and manufactured by Huawei, okay? And they're using radios that communicate, either satellite communication radios or internet-based phones, things that can potentially pick up packets and transmit information. If they're using Huawei equipment doing the work for you. So if there's 10 security guards and 5 of them are a subcontractor and they're all using Huawei equipment to do their jobs, that arguably is use by the prime contractor because they're being done, all that equipment is being used to perform the work required by the prime contractor. Again, this isn't the clearest. This is more just sort of our interpretation of how we've seen this. Obviously, there hasn't been any enforcement or anything yet either. So just.
So.
All right.
Oops,
yeah, go ahead.
Sorry, go ahead. Oh, I was just going to go into 204-25 is required flow down to subcontractors. That is implementing the prohibition at 889A1A. So that means that subcontractors must report within 1 business day to the prime anytime they notice that they're using these prohibited equipment or services. So that includes a whole slew of things here that you can see on the slide.
Yeah, and I'll say we got another question. I know we have a lot of questions, so we're going to try to get to them as much as we can. But there's been a question about another firm or other people have indicated that phones do not constitute a substantial or essential component and so would not be prohibited from use. I totally disagree with that interpretation of what the law says. It does not say, again, this goes back to the confusion that people have about substantial component. It's not that the phone is a substantial component to your business. The question is whether or not the prohibited equipment or services is a substantial component of the device your business uses. If your business is using a phone and it's made by Huawei, the parts in that phone are probably, at least in some shape or form, Huawei parts. And as such, those parts are probably vital and substantial components of that Huawei phone. And as such, they are substantial components of the phone that you are using. Therefore, that's a prohibited device. So that's been our interpretation.
Yeah. So in other words, there's no modifier on use in the law. It's not substantial use or critical use or anything like that. It's just use. The substantial or critical component gets to what the technology is made of, not the manner in which you use it, as far as we're reading this.
Right.
All right.
And so I think some of this too, let's go through the exemptions, because even if some of this stuff might be covered, there are these exemptions that apply.
Yes. So there is a blanket exception. Equipment cannot route or there's an exception in the case of equipment that can't route or redirect user data traffic or can't permit visibility into any user data or packets. This applies both to the government and to contractors. There's a government exception as well of connections to third-party facilities like backhaul roaming or interconnection arrangements. So that's a government use exception. Note that that exception does not apply to contractor use under Part B. There isn't an exception for contractors using services under Part B. And again, these definitions for backhaul roaming, etc., are contained in FAR 4.2101.
Yeah, and so it seems like there's been some questions too or confusion about this government exception, where folks have been asking, well, can I use, if it's just something in my backhaul or the interconnection that I have with folks, that's not me using it. Again, as Anna said, that exemption doesn't apply to the use piece, not to Part B, not to you. So even if you're using it in your backhaul and other things, that's still prohibited. The only exception that works for the contractor side of this is that the equipment cannot route or redirect user traffic or data, permit visibility into user data or packets. So the example I've used there is to go to security guards again. Let's say you're using Huawei shortwave radios. They have no way of communicating to the outside world, right? They're just shortwave radios, full stop. That would not be prohibited, even if you're using it on the federal contract, not a problem. Sort of thing, someone asked about a subcontractor who might have a Huawei phone and should they just leave it at home? If they're going into the office to do government work under the subcontract, should they leave the phone at their house when they go to work? Is it as simple as that? And I think because of the subcontractor rule, it would be. In fact, even if your employee has a Huawei phone, if it's a personal device of theirs and they use it sort of in their own time, right? Whereas their work phone is Apple, Samsung, whatever, that would also arguably be fine because you are not using the Huawei phone. That person might, but that person is not you. So there is some wiggle room in some of these rules. Another thing people are asking, well, there's telecom equipment, or let's say I have a supplier who supplies things in China to me. Do I need to know all the phones, for instance, that the employees on the production line have? No. Because again, if your contract with the government is to supply the product, then it's not, I wouldn't interpret this as being the entire supply chain. I would interpret this as you have to deliver the product, okay? So Part A certainly applies. So if this was a product that was manufactured by Huawei or one of the prohibited entities, then you can't provide it. But if it's a totally different product, just happens to be manufactured in China, then using that internally in your company, that's okay. Because frankly, almost everything, right? There's so many things that are manufactured in China or components that are manufactured in China that are not on this prohibited list. Also, the question of the reasonable inquiry comes up. So at what point does that sort of end? And it's not an easy answer. It's not clear. But I think if you're doing your best to say, well, these people are working in this Chinese factory, but they're just delivering me a product, let's say like tarps or something, and then I use the tarps on this government contract, okay? Well, I don't think you need to inquire about everything they're doing in their supply chain because what they're providing you is just a tarp. Whereas if the people in China were providing you telecommunications or IT services, that you were then using to perform the federal contract, or data analytics or something like that that you're using to provide the federal contract, you're communicating back and forth, it might matter. It might matter what those people, how they're processing the data, what computers are they using, what phones are they using, that kind of stuff, because they're working on the contract, and as the sub, the equipment that they're using is sort of a vital component of the work that you're doing, and therefore you as the prime could be considered to be using that equipment. So this is very fact intensive, and it's extremely confusing and open to interpretation, which is where the final rule is going to be critical in this, which is not helpful, I don't think, because the final rule might be a year away, which means we have a year of dealing with all of this. And so I think as new interpretations come out, or as the government continues to deal with this, we might learn more. What I've also heard is that DOD is trying to put some more meat on the bones, which is why they got a waiver, which, you know, we can kind of go to the waiver section. They got a waiver till September 30th, which gives DOD a little bit more time to figure out what they're going to do with this. And we wouldn't be surprised if other agencies do the same thing. But Anna, you want to run through the waivers?
Sure, yeah. So the Director of National Intelligence can provide waivers if he or she determines that the waiver is in the national security interests of the United States. There is not a limit on how many waivers the Director of National Intelligence can provide in terms of number. But all waivers, no matter where they come from, for the A1B provisions expire on August 13, 2022 at the absolute latest. And as I noted, DOD's current waiver expires on September 30th. 2020. And we'll see if the Director of National Intelligence decides to extend it more, or if DOD does something different, but we don't know that yet. So if an offer is submitted that doesn't comply with the rule, the contracting officer has to make a determination as to whether they want to go through the onerous process of seeking a waiver. It's probably going to be highly discretionary and not a basis for protest, just because, again, this is a statutory ban. And so protesting on the basis that the statutory ban should not be applied to you is a little shaky. If a contract is ongoing and the contractor cannot comply, again, the contracting officer could seek a waiver in that instance, but it's still discretionary and very difficult. The contracting officer could also just terminate the contract. And in the absence of a waiver, the contracting officer cannot exercise any option years. There are only two waiver types. There's the waiver from the Director of National Intelligence that I noted previously. There's also a one-time waiver from agency heads to a government entity, like a contracting office, for example, if the entity requests such a waiver. However, that waiver does need to, or the request for a waiver needs to include a compelling justification as to why it needs the waiver, has to give a whole explanation of how they're going to phase out these banned equipment and services. Agency heads can also grant a waiver if there's some kind of national emergency that just makes implementation of this ban too difficult. But no matter how the agency head grants the waiver, they have to notify the Office of the Director of National Intelligence and the Federal Acquisition Security Council. Either way. Also, within 30 days of that waiver, they have to provide a full description of the contract and use of each piece of prohibited technology, and they have to submit that to Congress, and an attestation that the waiver does not risk national security and how the agency came to the conclusion that it doesn't risk national security. So as you can see, there is quite a bit that goes into a waiver from an agency head. And again, that's a one-time waiver that can last at most through August 13, 2022.
Yeah, and so what we've been seeing, what we think is going to happen, is that this type of waiver from the Director of National Intelligence is something that an agency is going to seek for itself, just like DOD did. From what I know now, I see a couple questions. From what I know now, DOD is the only one that's gotten that. But I wouldn't be surprised if more people get on board now that DOD got that, and I also wouldn't be surprised if that's extended, assuming Congress doesn't do something to further delay this implementation. That waiver, the Director of National Intelligence waiver, is something that in theory is possible at the contract level, which is what we're talking about here, like if the KO goes and seeks something, but it's unlikely just because of the chain of command. So most likely when the KO is awarding a contract or looking to extend an option on one of your contracts, they're going to ask you, can you make the certification, the representation that you don't use any of this? You say no. Okay, let's say you can't make that representation. Then at that point, the KO, like I was saying, either terminate the contract or you go up here. And as you can see, what we just went through, the head of the agency got to go all the way up the chain, and then they have to write all this paperwork, talk to the Director of National Intelligence, and then provide this whole report to Congress. I don't think that's going to happen very often. And unless agencies just start ignoring this entirely, or it becomes so overwhelming that these reports to Congress just become a flood and no one's even paying attention anymore, which, let's be honest, that could happen. It could happen that there's just so much of this that no one cares anymore. Anything else, you just get numb to it. And so maybe Congress won't care. But as of right now, these requirements seem like they're pretty onerous. And it puts a lot of responsibility on the agency and on the contractors. That being said, there's a lot of things that the FAR Council is asking people to comment on in the next 3 weeks or so. I don't know, Andy, you want to walk through these?
Yeah, so comments to the FAR under this interim rule are due on September 14th, 2020. So like I said, that's in a couple of weeks here. 3 weeks, actually. The FAR Council is in particular seeking wide-ranging comments and answers to a few specific questions. You can see the questions here. But that would be if you know that you have this equipment or you use these services, it is a good idea to start looking into responding to this request for comments and just explaining how you think it would be best implemented.
Yeah, I think there's a good question here too about, well, what if we set an encryption such that, say, 256-bit or higher, like encryption to information that's flowing in, and then that information goes to a prohibited device? Is that still a violation? And I think if we go back up here, it's not whether the data that is important is being transmitted. It's whether the equipment can route or redirect user data or traffic, or whether the equipment can permit visibility into user data or packets that the equipment transmits or otherwise handles. So this doesn't give a carve out for if everything's locked down or encrypted entirely. I think the idea there is that if this equipment touches any data, in theory, the Chinese government, just like our guys do it, could crack or hack or get into anything at some point and find information. So there is no carve out for that kind of thing. It's the only exemption applies is if the equipment is not doing any of this to information. And by the way, it doesn't even have to be the government information we're talking about. If your company is using equipment that can do this to data, and let's say the only data this does it to is you have a private server set up, so when your husband or wife needs groceries, they communicate into you and it's in your system, inside your company, right? I mean, that might be a little ridiculous because then your company, is it really your company using it or you? But if it does a couple other things or whatever, and the information comes through there, it's not even important information, but your company is still using it. Or the other thing that's come up is, what if it's like a virtual server inside hardware that your company uses, but it's all the same RAID array of hard drives or solid state drives or whatever, and one segment of it inside the same piece of hardware is for your company versus others? I think that's where reasonable inquiry comes in. If you have no reason to believe that, like, your provider, your cloud services provider, whatever, use AWS, use Oracle, Oracle or you use, whoever. If the cloud services provider is not using generally that kind of equipment, you're probably okay. Or if you have no idea whether they are, I think it might be worth asking. And that goes back to, well, I don't know if I want the answer. But if you're saying you don't want the answer, I think that enters a risk that we'll get into in a little bit about some of the impacts. Actually, I'm going to just jump to it. At the end here, we're talking about False Claim Act implications, right? So if you know that you're using it, or if you recklessly disregard the truth, that can lead to a False Claim Act claim against you. And in this sort of circumstance, if you think or you have a hunch and you're just ignoring it, sort of burying your head in the sand, or you don't want to ask the question because you're worried about the answer you're going to get, that's the kind of thing that DOJ loves to use as reckless disregard for the truth, where you're not even attempting to get to the bottom of it. That being said, is there an argument that because it said you didn't need to do an internal or external audit, you just had to look at the information your company had on hand? Could you try to make that argument that we weren't required to do it, therefore it wasn't reckless disregard? I think there could be an argument there, right? But I guess it's a question of a business question of how difficult, harmful, costly, disruptive would it be to actually ask folks versus the potential risk on the back end of investigations and things that might happen in the future. Because I do think that key TAM relators, this is going to be like a plaintiff's lawyer's dream because it's so vague and so open. I know small business issues and limitation on subcontracting has been something that plaintiff's lawyers have started to hit people with. And I just see this as like yet another front, if you will, in potential False Claim Act issues. So I think there is a balance. And if you're asking or if you're looking and kind of taking a quick inventory of, well, what do I have? What are we using? Who are our providers? Oh, they're all US-based companies, or like they're a small business in Idaho that does our or Maryland or wherever that does our cloud services. That we have no reason to believe that they're not using standard commercial Cisco parts or whatever company parts. And frankly, a lot of the Chinese manufacturers haven't gotten a huge foothold here in the States, especially in the consumer market. But I think a lot of the stuff isn't necessarily Huawei or other Chinese manufacturers. A lot of the stuff is made by U.S. companies, like Dell and other people, HP. And if you're looking at that kind of thing, I think you could say, well, we reasonably believed that Dell, HP, whatever the systems other people are using didn't contain these parts, and we made a reasonable inquiry. We weren't required to do a deep dive or ask for a complete inventory on every single thing our cloud service provider is using. So that's kind of my take on some of the small business stuff. Do you want to go through some of the other impacts, Anna?
Yeah, sure. So the FAR Council has recognized that about 74% of the companies impacted by this A1B prohibition are small businesses. They've recognized that there will be a significant impact on contractors and on the government because of the increased costs, reduced competition, and potentially the inability to meet mission needs. They've also recognized that companies will leave the federal marketplace because of this prohibition. The cost impacts, of course, include possibility of claims for costs related to replacing your products and services. And of course, even if those claims are denied, you have the cost of replacing your products or services. There's also the cost with respect to time for inventorying your products or services. Again, that stops short of an internal or external audit, but you still should be aware of what you have and use. And the ban applies to whole products as well as components. As we've discussed, what does a reasonable inquiry practically look like? That's going to change based on who you are, who your subcontractors are, etc.
And I'll say also along the lines of how this is going to impact folks, we got a question too, and I've heard this concept a number of times, that look, we have a security camera that's made by one of the prohibited manufacturers and just looks at the front door, and that's all. I think there's a difference between, is it your landlord's building and your landlord uses it and you just go to work in that building, you lease space? arguably, if it's something that's in the front door, you're not using it. Your landlord is using it, and your landlord's not covered by this. If it's your building and it's used only for your business, then yes, it's not, that camera certainly isn't a vital component of your business, or essential or anything like that. But your company is using it. And are the components from the manufacturer vital to the working of that camera? Yes, they probably are. So that camera, if you own it and you have the building and you're using that camera to monitor the door of your building, then yes, you should unplug that. You should unplug it and disconnect it. Now, that being said, the other exception applies too. So if the camera can't communicate in this other definition that we have, right? If the camera, what's the exact thing? If it can't route or redirect user data or traffic or permit visibility into user data or packets or transmit information, right? If it just takes video and it has like a local hard drive on it or like flash drive, and you pull it out and then you can look at the video, that's probably okay because it's not communicating anything. However, if it's pulling that data and communicating all that video back to your server, it probably, that does have the ability then to reroute user traffic or data, and permit visibility into packets and other information potentially, right? So I think that goes into what does this equipment actually do and what's its capability and whether or not this blanket exception applies.
Right.
And that's kind of, but this slide, Anna, you want to go through the?
Yes, exactly. I mean, that really gets to what does using mean. Again, as we've been saying throughout, using the banned products or services applies to all parts of your company, not just whatever you use for government contracts performance. And of course, there's a question: what if the only contracts you perform are outside the continental United States? What about subcontractors or vendors who use the banned products or services in contract with you? These are still kind of open questions that, we've given some of our insights into, but it's just not clarified in the regulation as it stands. What if you have locations in China or somewhere else that use the covered equipment or service and no other options are available to you? What if China passes a tit-for-tat law? We don't know. And in any event, you should keep track of your agency waivers. Not all agencies, of course, will have a waiver, as we know. Of course, DOD is the only one who has one at this point, but you should keep track of that so you understand who you need to be talking to right now.
And I think some of the issues of, is there any, like the FAR Council asks questions of folks that go to some of these issues. Like, is there any other product that can do what it is you're doing? Should there be some carve out or clarification that things that aren't essential to your business or don't carry traffic and information that is vital to the performance of your business, like let's say that security camera. If all it is security camera footage that goes back to a server that only deals with the security camera stuff that isn't attached to other things, so that malicious software or hardware in the camera can't go back and start feeding into and phishing through the rest of your network, that's maybe possible, then maybe it's okay, right? But not under the current rule. But that's a question I think to ask the FAR Council or tell the FAR Council, like, look, we need more carve-outs for this because it's just not feasible the way it is. And then another question about, well, what everybody's working from home. Should I check my own router? Should I check other things? I did myself. I looked at everything just in case, like we're doing things as what we're doing our clients' use. Just in case, we're checking all of our stuff. All of our, I know the routers and equipment that I use here and some of our employees use and the cloud services stuff that we use is all clean. Like I checked all of that myself. So I will say that I took that step, just to be sure. But you don't have to take it all apart. So like I have Verizon. I have a Verizon Quantum router. I Googled around. I couldn't even find out who actually does the manufacturing of it very easily. I didn't spend that much time. But I think a reasonable inquiry is 5 minutes Googling, seeing what the heck's out there. That's probably even beyond what you need to do. And I couldn't even find anything. So check that box. Like we checked, tried to find information we could, or asked our IT people what their professional opinion was. And they said, well, I could do a few hours of research and figure it out. That's not reasonable inquiry. If they're like, no, there's nothing in here, I don't have any reasonable belief that there's stuff in the system. That's good enough, I think, under these rules. All right, so you want to go through the current bid stuff, Anna?
Yeah, so these are specifically getting to current bids that you would have out on the street. Part B only prohibits the offeror from using the covered equipment or services. So accordingly, you could just make a reasonable inquiry of your company only, then purge your company of all the offending equipment or services, and don't ask your proposed subcontractors yet, because you're not using them yet. But upon award of the subcontract, you probably should ensure there's language in the subcontract that requires them not to use the prohibited equipment or services in performance of your contract. Of course, if the subcontractor can't certify to that non-use, you probably shouldn't award that subcontract to them. That way, you can ensure that your prime contract is secure, you've made a valid certification, and you don't have to worry about your subcontractors yet. That's assuming, of course, you can perform the work yourself as needed.
Yeah, and this came out of some questions that I got about STARS 3 in particular, which is right around the corner, and everyone's like, what am I going to do about this? And the issue, I think, is as long as you can say you're not using it, and in the example of the person who has like the security camera, if you literally unplug that camera, you can leave it hanging there in the room. Just unplug it. And as long as you're not lying, you're like, well, I'm going to unplug it, make my certification, submit STARS 3, and plug it back in, right? As long as you're going to leave it unplugged, you should be good.
Yeah, because remember, there is the ongoing reporting requirement. It's not just a one-and-done certification.
But even that all of these things apply when you're doing the work. So after award, you've got all these issues. And same thing with subcontractors. That's why you can bid all this stuff and then deal with your subcontractors later at time of award. That being said, if they're critical, you're gonna default on all this work unless you are able to use these subcontractors. Then you might not have this option. You might have to ask them now and deal with it. But if there are other federal contractors, hopefully they're tracking things and being as diligent as you are. But again, it's not them using it in every aspect of their business like it is for you, the prime. It's them just using it particularly in the work they're going to give to you, and making sure they understand what their obligations are. So I think we're out of time. We're a few minutes over. I know we have a lot of other questions. I go through some of these questions and get back to folks on things. I want to be respectful of everyone's time. So appreciate you guys coming. And obviously this is something we'll be keeping a close eye on in the coming days and weeks as more information comes out. If there's any other waivers, we'll certainly be reporting them and some of the client alerts and things. And as new procurements are issued and bids go in, we're going to be also watching what the requirements are for those and see if things change. So again, we'll keep everybody up to date. Thank everybody for coming, and we will answer the questions and be in touch. Thank you.
Take care, folks.